Another day, another story. Section 41A of Criminal Procedure Code. Notice of appearance before police officer. 1. The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of Section 41, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. 2. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. 3. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless, for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. 4. Where such person, at any time, fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offense mentioned in the notice. Section 41B of Criminal Procedure Code. Procedure of arrest and duties of officer making arrest. Every police officer while making an arrest shall, a. Bear an accurate, visible and clear identification of his name which will facilitate easy identification. B. Prepare a memorandum of arrest which shall be, I. Attested by at least one witness, who is a member of the family of the person arrested, a respectable member of the locality where the arrest is made. E. Countersigned by the person arrested. And C. Inform the person arrested, unless the memorandum is attested by a member of his family, that he has a right to have a relative or a friend named by him to be informed of his arrest. Section 41C of Criminal Procedure Code. Control room at districts. 1. The state government shall establish a police control room, a. In every district, and b. At state level. 2. The state government shall cause to be displayed on the notice board kept outside the control rooms at every district, the names and addresses of the persons arrested and the name and designation of the police officers who made the arrests. 3. The control room at the police headquarters at the state level shall collect from time to time details about the persons arrested, nature of the offense with which they are charged and maintain a database for the information of the general public. Section 41D of Criminal Procedure Code. Right of arrested person to meet an advocate of his choice during interrogation. When any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout interrogation. Section 42 of Criminal Procedure Code. Arrest on refusal to give name and residence. 1. When any person who, in the presence of a police officer, has committed or has been accused of committing a non-cognizable offense refuses, on demand of such officer, to give his name and residence or gives a name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained. 2. When the true name and residence of such person have been ascertained, he shall be released on his executing a bond, with or without sureties, to appear before a magistrate if so required, provided that, if such person is not resident in India, the bond shall be secured by a surety or sureties resident in India. 3. Should the true name and residence of such person not be ascertained within 24 hours from the time of arrest, or should he fail to execute the bond, or, if so required, to furnish sufficient sureties, he shall forthwith be forwarded to the nearest magistrate having jurisdiction. Section 43 of Criminal Procedure Code. Arrest by private person and procedure on such arrest. 1. Any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and cognizable offense, or any proclaimed offender, and, without unnecessary delay, shall make over or cause to be made over any person so arrested to a police officer, or, in the absence of a police officer, take such person or cause him to be taken in custody to the nearest police station. 2. If there is reason to believe that such person comes under the provisions of Section 41, a police officer shall re-arrest him. 3. If there is reason to believe that he has committed a non-cognizable offense, and he refuses on the demand of a police officer to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, he shall be dealt with under the provisions of Section 42. But if there is no sufficient reason to believe that he has committed any offense, he shall be at once released. Section 44 of Criminal Procedure Code. Arrest by magistrate. 1. When any offense is committed in the presence of a magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. 2. Any magistrate, whether executive or judicial, may at any time arrest or direct the arrest, in his presence, within his local jurisdiction, of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. Thanks for watching. Please subscribe for more videos.